Onto this now, suspended Western Cape Judge President John Hlophe is racing against time to hang on to his job in a bid to stop Parliament's impeachment vote on Wednesday. Hlophe has filed an urgent application to stop the impeachment vote. He argues that Parliament cannot go ahead with the vote until his application to the Constitutional Court is finalized. Let's unpack this now, and we're joined by Mbekezeli Benjamin, a researcher and advocacy officer at Judges Matter. Mr. Benjamin, thank you very much for your time. Let's begin with that application at the Constitutional Court. Short question to you. Is it likely to entertain his matter, given that he has been there before?
Good evening, Billy, and good evening to the viewers. I doubt that the Constitutional Court will entertain this matter for two reasons. Number one, most of the issues that he raises in the Constitutional Court application are issues that he raised in the High Court application in Johannesburg, and he wasn't successful. And he took it on appeal, and before that appeal could be concluded, he's now taking it to the Constitutional Court. So I think he will have a problem convincing the Constitutional Court to take this matter now that it has failed in the High Court. The second reason is also related to the appeal, that he filed an appeal in the Supreme Court of Appeal in Bloemfontein, but he never went ahead with that appeal because he said that he didn't have the funds to proceed with the appeal. And so he's now going to the Constitutional Court while he's never concluded business with the Supreme Court of Appeal. And so for that reason, he probably will not succeed again, even though he's raising he's trying to raise a new point to say this has to do with a Parliament's failure to do its job, and so the Constitutional Court is the only court that can decide this. Basically, he's trying to engage the Constitutional Court's exclusive jurisdiction, but I doubt that argument will gain much traction in Bloemfontein.
The chief legal advisor to Parliament argues in court papers that if this were entertained, it would undermine the principle of separation of powers. Do you go along with that train of thought?
Yes, so the parliamentary advisor was speaking about the High Court application that Judge Hlophe has now filed, which is going to be heard on Tuesday. The reason why they're saying that it will breach the separation of powers is because Judge Hlophe is asking the High Court to stop the constitutional function of another arm of state. So he's asking the court to interfere with the role and function of Parliament, and that is a risk of separation of powers. In fact, the legal term for it is the separation of powers harm. So what Judge Hlophe is asking the courts to do is very well interfere with the job of Parliament, and that is only in exceptional cases, and I don't think he has made an argument that it is exceptional in this case.
His argument in court, I'm talking about Judge John Hlophe now, is that the National Assembly should have conducted its own probe to test the validity of the Judicial Service Commission's findings against him. Would Parliament even would it have the skill or expertise to conduct such a probe?
Look, Parliament would have such a skill and expertise, but Judge Hlophe departs from a misunderstanding of the impeachment provisions of the Constitution. When it comes to the President and when it comes to the Public Protector or any other head of a Chapter 9 institution, Parliament has every right to do an inquiry. They have every right to call witnesses, to examine those witnesses, to cross-examine those witnesses. So Parliament is the one that has that duty in terms of Section 194 when it comes to the Public Protector and Section 89 when it comes to the President. But when it comes to judges, it's different. The Constitution says that the Judicial Service Commission is the one that does an inquiry. the Judicial Service Commission is the one that has calls witnesses, that cross-examines witnesses, and hears direct evidence of judicial misconduct that will lead to impeachment. That is only for judges. So the Constitution itself makes it clear that the JSC has a particular role which involves an inquiry. Then the National Assembly, its role is more limited. The National Assembly receives the outcome from the JSC and takes a political decision whether or not a judge should remain in office. So the JSC takes the legal decision on whether or not a judge is guilty of misconduct, and then the National Assembly takes the political position of whether or not the judge should be removed from office. And so the Constitution itself makes it very clear that both bodies have very different roles. And what Judge Hlophe is trying to say is that Parliament must now take over the role of the JSC, and that can't happen. In fact, the High Court in Johannesburg told us that it's not possible.
What about the urgency element of the case? Is that something that the courts will consider, given the precedent-setting nature of this case?
Look, that one I think is an argument that might possibly succeed, because he probably will argue that the implications of the decision, if Parliament goes ahead on Wednesday after the budget speech and votes for his impeachment, that decision is irreversible, and he will be removed from office from that day, and that decision can't be reversed later on. So that is why he probably will argue in court that the court should interdict the decision until the resolution of the Constitutional Court's application. And look, it's difficult to argue against it, right, at this stage because of the implications that will happen on the judge. But the question of whether it is urgent is a different question, because he knew from November that Parliament is going to go ahead with this vote. And he only waited until the last month to file court papers to interdict Parliament from going ahead. And even so, when he went to the Constitutional Court, he never asked for an interdict, that the Constitutional Court must decide the case urgently and must interdict Parliament. He never did that. So I think that does weaken his point, but he does have a good chance that he will succeed in the Western Cape High Court.
Final question. A lot has been said about his benefits, lifetime benefits as a judge. If impeached, what happens to those benefits?
So the Constitution gives judges a salary for life. So, and from the point at which you are appointed as a judge until you die, you are entitled to a full judge's salary, even though at some point you go on retirement. But in the law, it's called you are not in active service. So you're no longer hearing cases in court, but you're still a judge, and you remain a judge until you die. But if you are impeached, and if Parliament votes to remove you from office and the President carries out that decision, then you are no longer entitled to that salary for life. So from the time at which the President signs your removal from office, you are no longer entitled to that lifetime salary. And usually, because judges have a lifetime salary, they don't usually save for pension, because that is essentially the pension that you will get. And so the implications is that if you are removed from office, you will lose the benefits, the 1.9 million rand that you would have earned for the rest of your life. You will lose it. You'll also lose the medical benefits that come with it. You'll also lose the car allowance, because judges are given a car allowance until they die. So you lose all of those benefits. You also lose the title and status of a judge. So you may no longer be called a judge. So there are real serious implications to a judge being impeached and removed from office.
Mbekezeli Benjamin, thank you very much for putting us in the clear about this matter of the suspended Western Cape Judge President John Hlophe. And Mbekezeli Benjamin, a researcher and advocacy officer at Judges Matter.